Florida law defines consent as intelligent, knowing, and voluntary consent and does not include coerced submission. Essentially, if you talk an unwilling person into saying yes, that's not consent. Former Tallahassee police officer Vincent Crump is accused of assaulting a woman during a traffic stop. Court documents showed the victim believed Crump had control and authority over her, and if she said no, he would use that authority to get her in trouble. I asked Tallahassee attorney Mutaki Akbar if coerced consent is hard to prove in sexual battery cases.
We can't get into a person's head and say, oh, that person was scared or that person was, being influenced by the law enforcement's authority. So I think it does make it difficult for the state to prove a lot of times, but at the same time, it puts people through certain situations as far as getting arrested, having to go through that agony of being charged with something serious just because somebody said, hey, that consent was not voluntary.
Consent also becomes an issue when drinking or drugs are involved.
When somebody's under the influence, the question then becomes whether they were sober enough to give consent, whether they're conscious enough or knowledgeable enough about their surroundings.
As spring break gets underway, Akbar has some advice.
If it's questionable, don't do it. You have to be in a situation where you know that person is doing it because they want to be with you as opposed to submitting to your authority. It's a long road ahead if that person makes allegations against you the next day.
In Tallahassee, Ashley Richmond, WTXL ABC 27.